lawyers come to me and say regulation and risk management is getting in the way of them doing their jobs. Is that true?
We look at the likelihood of risks crystallising within a firm.
The economics of going out and appointing a compliance and risk manager, it's so easy to work out.
You're looking at firms who may be self-reporting, but that's no different to other firms who are reporting effectively, potentially the same issue.
I'd like to ask a question of you about the appointment of risk managers and the fact that I think something like 15% of firms have now got a risk manager appointed to them. First, how do you know that you're an at-risk firm? Second, what do I do about being a not at-risk firm? And how can you help the people here to understand that?
Yeah, we have a dedicated team of relationship managers and or now called regulatory managers, and they will deal with what we deem high-risk firms or high-impact firms. These are typically the very large firms. Currently there are just over 200 of those particular firms. The remainder of the 11,000 firms sit within supervision, and they will be classed as either medium or low impact firms. We also look at risk assessments around probability. So we look at the likelihood of risks crystallising within a firm. And those two key components allow us to realise where we need to target our finite resource and also the types of things that we need to be talking to firms about. I mean, one of our key changes that's been brought about by OFR is actually how we deal with events that come through the front door. So traditionally or historically, we would probably write to you, we would put allegations to you and ask for a response. It didn't work. We need to engage with you, and that's one of the key things really to take away from today, is that we do want to engage with you. So we may be speaking to COLPs and COFers about the types of systems they have in place, the procedures they use, and that will allow us to decide what's proportionate and how to deal with that particular event. There is also a risk outlook that is being launched at the end of June. And again, I think this is a very useful tool because what it looks at is current risks, so what the SRA perceive to be the current risks out there, what we feel are the emerging risks, and also what we believe are the future risks.
Could I ask Paul and Trevor how you go about preventing the installation of a culture of fear and loathing inside the regulatory framework? Lawyers come to me and say regulation and risk management is getting in the way of them doing their jobs. Is that true?
If you're struggling with compliance and fitting it around a day job, then the economics of going out and appointing a compliance and risk manager, it's so easy to work out. You go back to the partners and you say, what's your hourly charge out rate? And they say 200 quid an hour. And if they do a 7.5 hour day, that's 1,500 quid a day. You go out and appoint someone and pay them 40 grand. That's £175 a day. So in less than an hour's worth of billing time, you've got someone who is spending all their time sorting your problems out while you're out there generating clients and billing them. And I think the same applies across all of the admin functions within a law firm. My firm, if you look at the inter-firm comparisons, is overburdened with these parasites they call admin. We don't see them that way at all, in that we are doing the management, the risk, the business development, the compliance, negotiating the PI premiums and so on. And we earn our keep, whilst the lawyers do the lawyering. And I think that's something that firms can learn from. Don't try and do compliance whilst you're trying to do all the other things. Professionalise it.
I think that's absolutely a key point, that we don't just want, it shouldn't just be a tick box exercise. It should be something that is someone that's driving compliance through the firm and through the people that work within that firm. Looking at root causes of things. So if there's lots of things that are happening of a similar nature, really looking beneath the skin of it and looking at, why is that occurring? Is it that there's a training gap with particular members of staff? Is it that systems are inadequate? So you're absolutely right. It shouldn't just be, I've done it, I'm a COLP, I'm okay, I've done my file audits. It's really looking at the reasons why things are happening. Driving compliance through every member of your firm.
To us, it's about training and cultural, issues. It's here, we can't get away from it. And as Claire's just said, it's important. We've talked to every member of staff about the new regime, about what these roles are and what the SRA expects of us, being the COLP and the COFA. And that, we don't have any choice in the matter. We have to fulfil these roles, and for the firm to practice and to be authorised, we have to go through these processes. It's a non-negotiable. But at the same time, freeing up those who are going to drive the business forward to do the things that will make the profit, and also trying to get a culture where people at the bottom feel comfortable about telling us about things that are going on that previously would have been swept under the carpet or whatever.
I think that's an important point. Is there not a suggestion that we better not tell the SRA about that because we'll get an audit, we'll be in trouble, and let's just not quite hush it up, but let's just forget it, we'll put it right, and we'll press on.
Very often what people may think is a huge problem. It's the same with a negligence claim. The sooner somebody knows about it, the sooner somebody with a fresh pair of eyes can take a view. And in the SRA's eyes, what may be a major problem, it's the way you deal with it. If you get the problem, you solve it.
That's a very key point. What we're trying to do is be very proportionate. So, in those circumstances, it may be that we look at it and we contact the COLP or COFA and say, have you remedied it? And what systems have you got in place to prevent that going forward? It will not be, tell the SRA something is automatically going to happen of a disciplinary nature. We're trying to move away from that.
To what extent do you see yourselves as policemen or as I guess helpers? I mean, if a firm hasn't had any breaches, whether material or immaterial, do they or should they look for things to report? Because if they don't report anything and there's a no report situation as the year goes on, that nobody's that good, So should they look for things to give you?
I think that the key thing behind that is if there have been no non-material breaches, it perhaps is a worry that people aren't reporting things to you. So are fee earners aware of the mechanisms by which they should be reporting to the COLP or COFA? Are they aware of the types of things they should be reporting? So I think over a 12-month period, I'd certainly expect perhaps some non-material breaches. Perhaps it's dependent on the nature and size of the firm. But I don't think people should necessarily go looking. I think part of the role is to oversee, the firm and to look at particular areas where risks may occur. But I certainly wouldn't go hunting for them. But perhaps just ensure that people are aware of the reporting lines, who they should be reporting things to, if and when things occur. I think that's perhaps the most important lesson there.
But as Vincent says, no one is perfect.
No.
And it was quite interesting. We merged with another firm. And our SAR reports have been qualified because we're a big firm. We turn over thousands of cases a year, and someone is going to cock up.
You're absolutely right. We are aware that mistakes happen. There are various case studies now. We've just launched a dedicated microsite within the SRA website, dedicated to COLPs and COFAs. That will hopefully give some comfort to the types of things we're looking at and the action that we'll take.
You've heard a lot from us to start with. Anybody got some questions for gentleman just down here? As
a non-lawyer, I was a bit disappointed when it was revealed that COLP had to be a lawyer. So I'd be interested to know if that might be reviewed or if there are good reasons for it that I'm not aware of.
Yeah, I think it's an interesting point, actually. It's not one that I've personally had before. I think it's very interesting with regards to the makeup of COLPs. It may well be something that's reviewed. There are lots of things that are being reviewed at the moment as part of sort of the red tape initiative, and that may be something that going forward, when we learn more about the COLP COFA roles, how it's working in practice, and points such as your experience that actually is very valuable, but you perhaps can't exercise it in a way that you'd like to. That's certainly something that may well be reviewed in the future once we're out of the sort of first year of the role.
how do you see Lexel as being valuable in improving the risk profile of a firm?
We don't look at firms and think, oh, they've got the Lexel badge, so everything's okay. You know, we don't see that as the be-all and end-all. We'll certainly look behind that and look at your risk systems and risk management, aside from the fact that someone's got a Lexel badge to their name. So it's certainly not the be-all and end-all accreditations.
Is your experience that we are more or less likely to trigger an SRA visit, or are we better at compliance than the bigger firms? Have we got risk better managed? Are we under control better?
I don't think there's really any differentiation. I think some smaller firms, medium firms, are actually very, very capable and very well equipped to deal with emerging risks or current risks that are occurring. And I don't think we should differentiate between actually the larger firms are much better, because that actually isn't the case. A lot of the things that are happening at the moment are affecting a whole wide-ranging firms. So from your big global firms to your very small sort of high street sole practitioners, etc. So I certainly wouldn't say that any particular group are dealing with risk or compliance any better than any others.
Does that mean we're all doing it very well, or we're all doing it very badly?
There's a mix, but obviously that there will always be a mix. So there will be certain firms that are very sophisticated, and very good at dealing with it, and dealing with risk and driving that through the firm. But there will also be firms that are struggling, perhaps not reporting things to us, perhaps don't have the correct people in the role. So it's very, very much sort of wide-ranging. We see a lot of different things coming through the door that affect a whole range of firms.
Okay. If a firm is in financial difficulties, Blakemore's being a recent casualty, should it have been the COFA or the COLP who reported? Because COFA is accounts rules compliance, really.
We've had, there have been sort of debates on this before, and one thing I would say is that the COFA role isn't really ring-fenced to look at accounts rule breaches, and that's it. There really needs to be very much a wider understanding of the financials of the firm, so reviewing cash flow, forecasts, profit and loss accounts, all those sorts of things. So I would probably say that does sit with the COFA in terms of that understanding of the financial mechanisms within the firm. Sorry, that's probably not not the answer you wanted.
Paul's a COLP, I'm a COFA. We were having an argument earlier as to which one of us should report.
Yeah. I mean,
not that we've got anything to report.
One of the key things is really being proactive with this particular area, because, you know, as you're quite right, there are lots of firms out there that I'm sure you'll all be aware of that have suffered financially, and as a result we've become very heavily involved. But we get a lot of reports that are very much too late, so it very much limits our ability to be able to do anything and work with the firms. So please, if you take away one thing from today, it's just to be very proactive with your reporting. As soon as issues seem to be crystallising, you must report them to the SRA. And the financial issue is very much a key one at the moment.
This is a point that's come up in a course I was on a couple of weeks ago in High Wycombe. There was a dispute, there was some variance as to whether your reporting accountants in their role as an independent audit, whether they actually had the right to see your breaches register. The way of thinking at the time, a couple of weeks ago, was in fact they didn't. I suggested that to our auditors, and there was an academic argument from the SRA, and the partner involved was fairly. I mean, obviously, I said, you can say anything you want, but he was a bit disappointed in that.
Yeah, I don't think there's an automatic right. I think the right really remains with the firm in terms of whether that information sharing, they wish to share that with them. What I would look at is it going to be useful for them? But I don't think there's an automatic right there. Obviously, that remains with us. There isn't a right to report to us. But in terms of external and independent accountants, I don't think there would be.
What's the breakdown, as far as you're concerned, Claire, with regard to financial reporting and legal practice reporting, and how much information do you get from the Ombudsman with regard to the latter? We
are seeing an increasing number of financial reports to us. Which in some way, it's good that firms are reporting those to us because we've been able to work with firms to work through those difficulties. So it may be that firms are thinking of winding down their practice, and we will work very closely with those firms in making sure that that happens in the correct way. So just sort of going back to my initial point is please report as early as possible.
What is the difference between a material breach and a non-material breach? And when does a non-material breach become a material breach? And do I have to have 5 of one to make one of the other?
That's very much up to the judgment of the COLP or COFA, and it wouldn't really be in the spirit of OFR to be providing a particular number. What's more important there is to look at the root cause of that. So why has it happened a number of times? And to really identify that and then work with that particular root cause to drive the compliance and mitigate that particular risk going forward. And another source of help which hopefully will be valuable to you is the website case studies that we've just published. So there's some case studies on there which are based on live examples of things that have been reported to us or where we believe they have been material or non-material breaches. So again, those will be reviewed periodically, and hopefully that will provide some guidance to you as well.
The annual report form, is that available yet so that we can see what we're going to have to report to you?
Well, no, because that's part of this red tape initiative. So we are consulting on that requirement at the moment. We're hoping to remove that particular requirement from the COLP and COFA so that they won't need to report non-material breaches annually. And if that's the case, our handbook will be altered in the October edition, which will reflect those particular changes.
I've been in practice for nearly 30 years now, and one of the key indicators of where a firm is going in the wrong direction has always been a breach of undertaking. In days gone by, we'd refer that to the Law Society, they'd jump all over it, and something would happen. When we report firms now to the SRA for breach of undertaking, the SRA completely disinterested, and I find that quite bizarre.
With our finite resource, what we will do is risk assess events that come through the front door and allocate supervisors to them in accordance with the particular score that's allocated to them. So, that will look at the severity and the impact on clients and the sort of the credibility of that particular evidence. Because what obviously we need to do is to tackle those firms that pose the greatest risk to us. What we're trying to do is obviously be a lot more sort of proactive. So we will contact firms potentially in that case to discuss, why is this taking so long? Why haven't you fulfilled undertakings? What's your system? What's your mechanism for making sure those are done? But I appreciate on every particular piece of correspondence or report that comes into us, we haven't got the resource to deal with all of those, and it's very much based on risk.
A report such as that is probably an indication that the firm is in financial trouble. There's some story behind it, and it is something that ought to have high risk placed to it, because you're looking at firms who may be self-reporting, but that's no different to other firms who are reporting effectively potentially the same issue.
Yeah, absolutely.
And there's clearly potential detriment to the clients.
You're not going to self-report breach of undertaking because we're involved in a mortgage fraud. You're not going to self-report that.
No.
So I don't think self-reporting is the only evidence you should be looking at, no.
No, absolutely.
I'd like to thank all of our panellists, but in particular Clare for being so open and so welcoming in the way that she's answered the questions. Thank you.